Welcome back to the channel, everyone. And I wasn't going to do this. I was going to go react to some fun things, but I got bombarded with a bunch of messages that I had to go check out the MadCaster video on Illuminati. I haven't looked at any of MadCaster stuff. I know for a fact that MadCaster is a lawyer, and if you want to know all the nitty-gritty details of the lawsuit, go straight to their channel. I'm going to have a link in the description. And their channel, if you're going to support any one channel, support that channel, because they actually have, you know, a valid reason for the money that goes into their channel because it supports their charities for cats and rehabilitation and a bunch of other things. If you like cats, that is, go support them. But we're going to go through this, and I'm going to be very interested in what's going to happen here. Let's see here. I didn't even test and see if my headset was working. So let's find out if I have audio.
I'm glad to see you here. Well,
okay, I do. 1 second, but it's not even close to high enough. Okay, so apparently Illuminati won part of the initial part of the lawsuit, which I wasn't surprised at, because I figured there's definitely some missing information. That's because, don't forget, Blair has basically been silent this entire time, so we don't know exactly what she's doing in the background, which honestly is a lot smarter, I think, than putting stuff online, because the moment you start throwing stuff online, it ends up getting thrown into the court. Now, there's a good side to that and a bad side to that. The good side is, you know, you get more eyes on it, so you're going to get more support, potentially in Oz and Felix the Cat's case and Wonder's case. They're all going to get additional money. From what I understand, is their legal fund is probably over $50,000 in the last week or so added to it, which is good. Maybe even higher. They're definitely going to need more, so keep donating if you want to keep helping. But yeah, let's see how it is. My big thing is, I bet you some of Oz's stuff is going to get dismissed, but from a lawsuit victory, I think Felix is probably the one there where it's going to get is more. I think he's more likely screwed than Oz in certain ways, just because I'm pretty sure Sad Milk is a subsidiary of Pyramid, and because of that, there was a good chance that he was actually working for Pyramid without realizing it. So he may have actually broken the non-disclosure agreements then. But
the court has finally ruled on the 2 pending motions to dismiss in the Illuminati lawsuit. It's kind of a mess. It's not as clear-cut and as...
It's always a mess. All lawsuits are a mess.
neat as I would have liked to have seen. We're going to talk about what the judge has done. I've got copies of both the decisions because, you know me, I've got the deets and all the receipts.
At least he has access to actually getting actual information versus all the other random people on the internet who kind of just find potential information that may not be real. I can actually say MadCaster actually has the ability to get actual information, though.
We've also got Cedric being a pain today. So buckle up and let's go.
So yeah, go donate to MadCaster's channel.
So welcome, you guys. We have passed the 50,000 subscriber mark. We're actually almost at 51,000 subscribers. Can you believe it? Thank you guys so much for getting us here. And also, if you're not subscribed, please like and subscribe the video. We're going to talk about now the 2 decisions that came down from the judge in the Illuminati lawsuit. It's really a mess. And I'm going to explain to you my opinion on some of what the judge had to say. It's sort of a good news, bad news kind of scenario.
Let me guess. This judge, and like a lot of judges, they're really old or a lot older, don't understand how YouTube works. And they're kind of treating everything as, you know, what they're used to type of deal. That's what I'm going to guess.
We're just going to go over, the decisions aren't that long. We're just going to go over both of them. And I'll give you my opinion whether I agree with the judge or not on some of the things he said. So let's get into it.
I'm sure you've all heard of data brokers where companies like take all your...
Oh, he has a sponsor. We're going to just skip past the sponsor today.
Things that it does, and also they have a really great app that you can use that. My information had been compromised from AT&T, I know I don't have to worry because, or
If your data is ever, well, everyone's data always gets compromised to a degree, believe me. But if you ever want to check out to see if your email's compromised, there's a website called haveibeenpwned.com, and it'll let you know which data breaches your email address is part of, as well as phone number. And that's a pretty good site.
or is
It's
going
free
to keep
too.
me safe and take care of it. I value my privacy. I'm sure you do too.
The first decision that we have, we'll talk about, concerns Oz Media's motion to dismiss. Now, you remember the court has allowed Blair, the Illuminati, to amend her complaint. So she had a complaint, an amended complaint, and a second amended complaint. Something else comes up in this that really irks me. We'll talk about it in a minute. And then Oz basically had to do 2 motions to dismiss because once she got permission to amend her complaint, again, that motion that he...
Yeah, it's kind of weird that the judge was, or that Illuminati was able to amend her complaint so many times. It was like 3 times, which is kind of rare, I think, in a lot of ways. Unless you're like a political figure. Then you can amend your complaint like 60 times.
first filed was no longer relevant. So let's take a look first at this Oz Media motion to dismiss decision. And it's, Pyramid Entertainment versus Oz Media, and there's the other defendants. And here's the order regarding the motion to dismiss. It says, before the court is a motion filed by defendant Oz seeking dismissal pursuant to the rules of civil procedure and the anti-SLAPP statute of plaintiff's claims against him in the second amended complaint. I have previously allowed 2 amendments of the complaint, following which Oz renewed his motion to dismiss. I have reviewed the renewed motion, the response, the reply, along with the case file and applicable law. So remember, he filed the motion, she filed her response to that, and then he filed a reply, and we've covered all
So he filed a reply with a case, basically previous case law to help bolster his reason to have it dismissed, correct?
3 of those different pleading. If you haven't seen my other videos on Illuminati, please watch them. And here's the applicable standard on a 12b5 motion to dismiss. When considering a motion to dismiss for failure to state a claim, Colorado courts until recently applied the no set of facts standard, dismissing a complaint only if it appeared beyond a doubt that the plaintiff could prove no set of facts that would entitle him or her to relief. In 2016, the Colorado...
Okay, if that's true, that gives the plaintiff like a massive, like, blanket move. Effectively, they can be like, well, at least one of these complaints works.
Supreme Court modified that standard by adding the requirement that the complaint state a plausible claim for relief.
Okay, so it has to be plausible, but still, before 2016, you could just basically say whatever, apparently.
The court went from this rigid, absolute, you can't prove anything, to you can't prove a plausible claim. So I think it's a little bit more favorable standard for the defendant. Under the Warren standard, the trial court still accepts all allegations in the complaint as true and views them in the light most favorable to the plaintiff. However, facts pleaded as legal conclusions, i.e. boilerplate or conclusory allegations, such as those that merely repeat statutory language, are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief.
I think this is where Illuminati kept failing because he wasn't putting down very specific things that were happening, right? And then it was just kind of like just standard complaints, which is why the court got mad and had her amend it twice or 3 times.
Above the speculative level. So there has to be some, at least kernel of possibility that the claims are entitled to relief by the court. The courts are fairly liberal in giving leeway to the plaintiffs when considering a motion to dismiss because they don't want to just dismiss it out of hand if there's any chance, no matter how remote, that maybe some of it is true and can be proven. They want to see the evidence.
That might be because if a judge is found to be basically just ignoring complaints and things like that, that may get them, effectively fired, and or maybe the city could be sued in certain ways. So
and not just go on the pleadings. So keep in mind now, as we go over these, that
doesn't mean that Illuminati is not wrong. It just means that they're going to force it to trial.
Because the judge might say something that's favorable to Blair and unfavorable to Oz or Felix the Cat does not mean that the court thinks that she's right or that what she's saying is true.
Right. They just need they're just not sure that they can dismiss it 100% out of hand until it goes to trial, and that's what trials are for. Judges just get rid of the really stupid ones.
The court is merely saying that it's enough, in the court's opinion, to move on toward the discovery phase and eventually to trial, so that the evidence can come into play more to show whether or not she's right and whether or not what she says is true. So just keep that in mind. What we're going to read here in no way means that the judge believes Illuminati over the defendants. That's not what it means, okay? Simply asserting a legal conclusion bereft of any supporting factual allegations does not state a plausible claim for relief. A motion to dismiss for failure to state a claim is a challenge to the facial sufficiency of the complaint. It is directed at the four corners of the complaint, and accordingly, a court generally may consider only those matters stated in the complaint. However, Rule 12b provides that if additional matters outside the complaint are presented, the court has discretion to take those matters into consideration and convert the motion to a motion for summary judgment. So a motion for summary judgment is basically you're saying to the court has all the evidence and proof it needs. There's no need to go any further with this, judge. So basically they're saying, judge, we want the court to rule right now, based on everything that's been presented, that there's no merit to these claims at all. It's not necessary to go to trial. And I told you guys before, too, that it's very slim odds that the court is going to grant a motion for summary judgment unless it's really, really clear that this is a dog of a case and there's no way that the plaintiff's ever going to prove what they're stating in the complaint. After giving all parties reasonable opportunity to present material that would be relevant on a summary judgment motion, he's saying, I elect not to do so as the motion has not been fully briefed in that posture. So basically the judge is saying he doesn't believe that the motion to dismiss has enough material or enough evidence or enough information in it.
Right. So it's not going to be just a quick summary judgment. It's going to trial.
For him to be able to rule as a motion for summary judgment. And he goes on to say, if matters outside the complaint are submitted to the court but not considered, it is within the court's discretion whether or not to convert the motion to dismiss into one for summary judgment. So he goes on to say that in 2019, Colorado enacted the anti-SLAPP statute to address lawsuits aimed at stifling or punishing the right to free speech, commonly known as strategic lawsuit against public participation, and to provide a procedural mechanism for the early consideration and dismissal of such lawsuits. Colorado's anti-SLAPP statute is directly modeled after California's statute and also codifies pre-existing Colorado case law. The anti-SLAPP statute provides in pertinent part as follows. A cause of action against a person arising from any act of that person in furtherance of the person's right of petition or free speech under the United States Constitution or the state constitution in connection with a public issue is subject to a special motion to dismiss unless the court determines that the plaintiff has established that there is a reasonable likelihood that the plaintiff will prevail on the claim. Colorado follows California's two-step process for considering the special motion to dismiss under the anti-SLAPP statute, and Colorado's courts look to California cases for guidance on how to apply the statute. And we talked about this too, not only in the Illuminati case, but in the Janet and Lauren the Mortician case against the girlies, that they've also raised anti-SLAPP. And Georgia also is one of the states that looks to California for guidance to see how California interprets the law and to get guidance from that.
I don't know if that's a good idea.
First, the court determines whether the defendant has made a threshold showing that the conduct underlying the plaintiff's claim falls within the scope of the anti-SLAPP statute. That is, that the claim arises from an act in furtherance of the defendant's right of petition or free speech in connection with a public issue. An act in furtherance of a person's right of petition or free speech in connection with a public issue is defined to include 4 specific types of acts, of which the third is relevant here. Any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest. If the trial court finds that the claim falls within the statute's scope, it then proceeds to the second step. It reviews the pleadings and affidavits and determines whether the plaintiff has established a reasonable likelihood of prevailing on the claim.
Wow. I haven't watched a MadCaster video before, but man, if anyone's going to go straight into the details of everything, it's this guy. Definitely go watch his video.
The court determines that there is not a reasonable likelihood that the plaintiff will prevail in the claim, the court must grant the special anti-SLAPP motion to dismiss and award the defendant their attorney fees and costs. So now we move on to the first subject, the breach of contract claims that Blair made that Oz has asked the court to dismiss. The first claim for relief for breach of contract alleges that Oz entered into an agreement with Pyramid, the Oz agreement, that required that he not use confidential information and or proprietary data for the benefit of any other person, corporation, or entity other than the employer.
I don't think Oz did breach of contract, did they? I don't remember Oz being part of the breach of contract. I thought that was only Felix.
During the term of employee's employment with employer or any time thereafter. Remember we talked about it. She doesn't put a reasonable time limit on this. At any time implies it's open-ended. It's forever. If Oz challenges the validity of this agreement, my guess is that a court would find it's not reasonable and would probably throw it out.
I guess in this case, it could be just him talking about all the stuff he went through that could, in theory, be a breach of contract, but I don't know. I could see the judge dismissing this part.
They haven't asked this court to do that, so the court's not going to address whether it's valid or not.
Okay.
They're just going to look at the document and determine whether the conduct Blair complains of is actually a violation. And that he breached the agreement by using confidential proprietary information to defame or otherwise harm plaintiffs. Example of these breaches are set out in paragraphs 41 and 46 of the complaint. The complaint also references paragraphs 58, 59, 63, and 64, but these paragraphs refer to alleged breaches by other defendants. Oz contends that the breach of contract claim against him should be dismissed pursuant to Rule 12b-5 because it fails to set out with particularity his statements or other conduct that allegedly breached the agreement. The anti-SLAPP statute is not implicated by the claim. Paragraph 41 alleges that in April of 2023, Oz published a series of Twitter, now X, posts naming Blair as the aggressor and falsely claiming that she has a habit of starting fights. These posts also included Pyramid's confidential information. This is what Blair's claiming in the complaint.
Yeah, okay, so if the question here will be is what does Blair have that hasn't been posted yet? Because if Blair has a bunch of stuff in the background that we're not aware of and that's missing, that could be a problem for us.
A link to a Twitter address follows, but clicking on the link does not produce the alleged post.
Oh, well, okay. That's a fail on Illuminati's part.
So the court tried to use the link that she provided, and it was broken. Paragraph 46 alleges that in September 2023, Oz released a YouTube video titled Let's Talk, an update on Illuminati drama, which contained accusations in which Oz falsely accused plaintiffs of embezzlement.
He probably should have just never used that word. Even if he technically wasn't implying that, he probably should have just never used that word.
Nothing in either paragraph sets out the specifics as to how Oz purportedly used confidential or proprietary information to defame or otherwise harm plaintiffs. And so there's a footnote.
Okay, so it says the judge right there saying there's nothing here. That's good.
Here that the judge put in that I'm going to read because it's important. It says the court notes that in its order of January 15, 2024, authorizing a second amended complaint, the court instructed plaintiff that all statements on which they relied shall be set out verbatim in the complaint. That order was necessary because plaintiffs, in their previous iteration of their complaint, had failed to specifically set out the statements by defendants that they alleged were defamatory, making a substantive review of the complaint impossible. So the court's saying, we don't have enough information.
Right.
You're not telling us what it is that's defamatory. And this is true of some of the other cases we've talked about, too, where the courts have basically scolded the plaintiffs for not putting...
A lot of people, when they make a complaint or for a lawsuit, they don't put even remotely enough detail into what they actually mean. And courts are like very black and white in a lot of ways. So they're like, yeah, you either tell us exactly what it is or just no, go away. We have too much shit to do already.
The detail that is necessary to show why there's actually a cause of action here. Plaintiffs have again failed to comply. Amen. A link to what purports to be a Twitter thread, even a link that works, is not the same as a verbatim representation of the specific statements to which plaintiffs object.
Basically, she would have had to have written it down entirely, right? And it seems like she was just skipping work.
Leaves the parties
kind of like a lot
guessing,
of the stuff she does.
and accordingly, it violates the court's very direct and specific order. Finally, identifying the statements in their motion response is inadequate. The statement must be set out in the complaint. So they're saying you can't correct it after you failed to heed the court giving you these instructions more than once by putting out a response to the motion to dismiss and then putting some of it in there and saying, well, here it is. Their point is the complaint has to be complete.
So the downside then is, why was she allowed to do it the third time?
In itself, your whole position that you're putting forward of why something has wronged you and you're entitled to relief, the information has to
Because don't forget, she had lawyers helping her. It's not like she was doing this on her own.
be contained in the complaint so the court knows how to review it and how to analyze it. He goes on to say now, as noted above, under the Warren standard, boilerplate or conclusory allegations are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. No such specific factual allegations support this claim, and accordingly, it is dismissed. So the court has dismissed the breach of contract claim. So, I mean, technically now, really, the whole issue with the confidentiality agreement is kind of moot at this point because it's no longer going to play a role in this lawsuit as far as Oz is concerned.
I was like, that makes perfect sense for Oz. Lucky for Oz, but I still think Felix is going to have a bigger problem.
Because the court said, you didn't do what I told you to do, it's dismissed. Hallelujah. Thank you, Judge. Absolutely great. Now, we get on to the defamation claims. Oz contends that the remaining claims against him, the third and fourth causes of action for defamation, should be dismissed pursuant to the anti-SLAPP statute, or in the alternative, pursuant to Rule 12b.
Oz is lucky that he's in America, though. At least he has a chance to fight this. Whereas if he's in like South Korea or Japan or something like that, a lot of those countries, even if you're right and it's 100% proven, you still can't say it because it's still gonna come back against you.
5 for failure to state a claim, which is what the court looked at when they dismissed the breach of contract claim, was 12b-5 for failure to state a claim. The statements identifying claim 3 made in a YouTube video by Oz after the case was filed accused Blair of embezzlement, and we talked about that. He didn't.
Okay, so he never technically accused her of it. That's correct, but he used the word, and the problem with the courts is they're just gonna hear the word. A lot of these courts don't understand how YouTube works at all, which is why there's such a blanket statement on how reaction channels can work.
Not accuse her of embezzlement. He made it clear he wasn't sure what she said. He's saying she brought that up. Anyways, we've talked enough about that.
The problem is, that's going to be more he said, she said at this point. So if she has it on video, maybe, but I don't know.
The statements identified in Claim 4, made by Oz in the same YouTube video, accuse her of having placed him in a dependent, arguably coercive financial relationship.
Yeah, that's more interesting to me. I want to see how this was going to play out and see if the court even applies any of this, because there's a lot of what everyone else online sees, and then there's what the court's going to see, and they're just going to look at the hard paperwork and numbers
with her. And then video. He goes on to analyze whether the anti-SLAPP statute applies here. And this is what he has to say, and I don't agree with him. The judge says, I find the anti-SLAPP statute does not apply because Oz cannot satisfy the threshold part of the analysis. While the parties agree that Oz's statements were made in a public forum, they were not made in connection with an issue of public interest.
Now, I guess it depends on what it means by public interest. So, do anti-SLAPP laws in Colorado only affect like political type anti-SLAPP stuff? Or does it have to be like a public forum in the state itself versus YouTube, which is even though they're in the state, technically it's an online public forum, which is worldwide. Could be that. Maybe it's more specific on how they can apply it to only local type stuff, like news, for instance, news companies that are local, but they couldn't necessarily apply it to a news company in, say, New York. So maybe it's something along that lines.
Now, we talked about public interest before. Oz's attorneys cited some case law. I disagree with the judge here. I think it is a matter of public interest, and I'll talk a little bit more about it, but let's just continue and finish reading this, and then I'll talk.
Also, MadCaster's an actual lawyer, so He's going to have a much better opinion than I am on this.
Talk about it. Neither of the statements identified in claims 3 or 4 were made in connection with an issue of public interest. While they were made in the public forum of the internet, and while Blair may or may not be a public figure, they arrived.
Yeah, so I mean, that's the thing. What's a public figure? Are YouTubers public figures? Maybe not. I mean, you know, like, what was it, Alex Choi? He just got arrested for launching fireworks at a Lamborghini from a helicopter. Would you consider him a public figure? The courts may not think so. The courts may just think of him as an online idiot. The question is public figure only like someone who's not connected to online, only online public stuff? Like, for instance, Hollywood stars are public figures because they're not just online, but they're also part of a, you know, the actual corporation kind of move of the world, you know, Hollywood. But, you know, politicians are, you know, public figures. So maybe in their eyes, no YouTubers will ever be public figures because that's not the same type of form they're thinking it is.
Rise out of a private dispute between Oz and Blair, and they solely address that private dispute as opposed to larger, more public issues. Now, and they cite this damn veterinary case that Blair cited to, which I think totally irrelevant and is not on point here. Here's the thing. Yes, correct. It was a private dispute. However, it became a public dispute. Both parties.
That's the thing. But is it a public? Does the court recognize YouTube as a public? Like, they know it's a public forum, but they may not actually recognize it as a public dispute based off Colorado law. I think that's what's potentially missing here, at least for the express reason to automatically dismiss it. They might still believe that this is a public dispute in general, but they want to put it to trial because they're not 100% convinced it's 100% a public dispute just because of how YouTube works. Because there's a good chance this judge doesn't know how YouTube works.
Made it a public dispute when they went into excruciating detail on both sides, whether what they allege is true or not, about these issues and put it out there in a public forum. So, yes, it may be a private dispute, but it is.
Like, for instance, maybe Colorado believes public forums are like town hall meetings, only out in like your local area or within the state, you know, setting as a public, you know, like on TV or something like that. That's local. Maybe they don't consider the internet a public forum in the same regard. That could be, or this judge is just like super lenient.
It isn't anymore. It's now in the public. And the public is obviously very interested.
It really depends
on
how the law works.
Supports that conclusion if that's what the judge is trying to say here. And I think for the reason I just stated that, yes, it may have originated as a private dispute. It's no longer a private dispute.
Oh, that's true. It's definitely not private. It's all over the internet. And it's every 10 days there's an update.
Courts have kind of broadened that beyond. It's not just about like things going on in the community, you know, issues of public interest. It's stuff.
That's what I'm worried about. See, maybe this judge is thinking, you know, maybe that's their version of how the public dispute works, only within the local community of public discourse, or their state, because of how the anti-SLAPP law works. It's only, you know, linked to their state, which is interesting considering they're both in the same state.
That the public's interested in. I mean, clearly the public's interested because it's garnered a lot of attention.
But it's only garnered a lot of online attention. It's not garnered any local attention, which is why I think the problem is.
From the public. He goes on to say the statements by Oz express a personal grievance arising out of their personal relationship. They lack any nexus with any issue of public interest, and they do not contribute to any broader public discussion.
Yeah, is this a public interest within Colorado is what I think the judge is probably trying to say, which means the anti-SLAPP statute of Colorado does not apply here. So I think that might be the problem.
Discussion of any social or political issue of public interest. Thus, the anti-SLAPP statute does not apply. I don't agree with you, Judge. Again, that doesn't mean the judge is siding with Blair or thinks that
That just means the judge thinks that they can't make a ruling on it because it's not based off the anti-SLAPP local ruling, which means it could still apply, but it may have to go to trial to apply.
He's right. He doesn't think that he has grounds to dismiss this count. It needs to proceed on the trial track. So He's not going to just toss it out at this stage. And so he goes on to analyze this. Because the anti-SLAPP statute does not apply, the court must assess whether the claims against Oz satisfy the Warren standard, so whether it can be dismissed for failure to state a claim instead of for anti-SLAPP. The traditional elements of defamation are a defamatory statement concerning another published to a third party with fault amounting to at least negligence on the part of the publisher, and either actionability of the statement irrespective of special damages or the existence of special damages to the plaintiff caused by the publication. Oz contends that plaintiffs must meet the enhanced actual malice standard set out in New York Times v. Sullivan because the challenge statements relate to a public figure. That standard also applies.
Okay, but that only works if Blair is considered a public figure, though. And just because you're famous on the internet does not make you a public figure necessarily. Just because you're a famous influencer with 100 million followers doesn't necessarily make you a public figure in, regards to how the law works. So I think that's the biggest problem potentially. Now, the question is New York Times or Sullivan. Is Sullivan an online only persona? I don't know who that would be. I'd have to look into the actual case. But if they were, let's say, an online, fitness influencer or whatever, and that's it, then maybe that could relate because that could make them a public figure. But I just don't know if the law considers internet's YouTube celebrities public figures, like Mr. Beast. Mr. Beast might or might not be considered a public figure. They would only be maybe considered a public figure because they do a lot of stuff in their local public, community, and they would be known as a public figure because they do a ton of stuff within their local area. Food banks and things like that. But who else would there? CoffeeZilla, for instance, millions of subscribers, probably isn't considered a public figure in any way, even though they're, a massive YouTuber. So it's probably along those lines.
If the statements relate to a matter of public concern, but as discussed above, they do not, in his opinion. However, I will not apply the actual malice standard in this posture because the evidence as to whether Blair is a public figure consists for the most part of matters outside the four corners of the complaint. I'm not quite understanding why he's saying this. So basically he's saying, well, it wasn't
Okay, so he's saying that he doesn't care if she's a public figure or not?
argued in the complaint that she's a public figure. That's something the court has to decide based on an analysis of the whole situation.
Which might mean that's why they're going to trial versus this. Okay.
And he's claiming, oh, it's not in the four corners of the complaint, so we can't decide whether she's a public figure. I don't know. I think it's absurd. And I decline to convert the motion into a motion for summary judgment. Thus, for the purposes of this motion, I will apply the traditional elements of a defamation claim as set out above. Oz's challenge focuses first on the first element of the claims, namely whether his statements were defamatory. To determine whether a statement is defamatory, the courts employ a two-part test. A court must determine whether the statement consists or implies a verifiable fact about the plaintiff. And second, whether the statement reasonably is susceptible to being understood as an assertion of actual fact. Claims 3 and 4 meet this standard. The statements made in both claims contain or imply verifiable, I guess he's talking about.
And this is why most YouTubers, when they get a cease and desist or any sort of any sort of claim against them, they would just delete the video because they don't want to deal with this. They do not want to go to court. Especially if someone has a lot more money than them and can just bleed them dry over some nonsense stuff.
When the evidence is presented and through discovery, whether or not it can be proven that she embezzled. So apparently there's going to be a lot of financial documents coming.
Oh, I can't wait to see the discovery. I'm actually really, I can't wait for that, and I can't wait for people. I'm going to put a link in the description and be like, look at this horrible take I had at the beginning when I didn't know anything about Illuminati, and people just yelled at me for 20 minutes.
From Blair's side in discovery. So I hope she's prepared to, shine a light on her financial dealings. Claims 3 and 4 meet.
The problem will be is if they're actually all above board. They probably aren't, but if they are, then there's going to be a lot of interesting stuff going on.
This standard. The statements made in both claims contain or imply verifiable facts about Blair that she committed the crime of embezzlement and that she placed Oz in a dependent, coercive financial relationship. Oz contends next that plaintiffs have failed to sufficiently prove special damages in connection with Claim 4, defamation per quad, contending that the drop in revenue alleged in that claim occurred before rather than after the contested statement. That is, in fact, what the complaint alleges.
I mean, I'm not sure about that part of the complaint. YouTube is so fickle on how its income works. One day I'll make $8, another day I'll make 42 cents. So that's not really necessarily, and it's not. It wasn't just Oz's video that came out. The big video drop was probably the clicks video. That video like crushed her channel because the click came with every receipt possible known to man and then some. And then, you find out Illuminati allegedly has 5 different sock puppet accounts, which you can go find. And there's probably more that people don't know about.
Do not consider the additional materials that Oz submits in connection with this argument. Claim 4 is based on a September 16, 2023 video, the Let's Talk video, but it then alleges that Oz's statement caused special damages as evidenced by the fact that plaintiff's revenue from videos dropped by more than 95% in the period September 16, 2020.
Nah, they were gonna drop regardless, even if he hadn't put out that video. To be fair, it probably would have been at a much slower rate. It probably would have been half that speed. But even then, it doesn't necessarily matter. Although the law might consider it a problem. I don't know.
To October 1st, 2022, from $47,665 down to $2,312 during the same period a year later.
I want to make $2,000 a month
drop
in
revenue
YouTube.
Took place in the year before rather than after the Let's Talk video. As a result, Claim 4 fails to plausibly allege the required element of special damages.
I want to see the year before that. Give me all your information on the year before that when you were way lower as well. So, I mean...
Accordingly, I find that Claim 3 satisfies the warrant standard, but Claim 4
basically
does not.
just chose her highest years.
Basically, he's dismissing the claim for special damage. She's comparing a whole year's worth of revenue, most of that occurring before Oz's video came out. That doesn't show me that your revenue dropped precipitously right after he posted his video. You're saying that it dropped over a 1-year period. I know.
Right. Like, maybe if she was suing the click, for instance, then you saw her video drop literally from $68,000 a month to $2,000 in the next month. Then I could say that that video contributed to it.
Finally, the complaint is defectively pleaded.
But she's not going to sue the
in
click.
that it fails to set out each alleged defamatory statement in the form of a separate claim. So the judge wanted to see count 1, defamation, and then a statement. Count 2, defamation, and then a statement, rather than lumping them all together. Only those that have been separately set out in claims 3 and 4 will be considered to be claims for defamation. Those that have not been set out in that way will not be treated as such. So he's not going to consider any other allegedly defamatory statements.
So there's 3, whatever's in 3 and 4 then, huh?
The embezzlement allegation and the one about the coercive financial relationship. I mean, that...
those are the 2 big ones, yeah. Now, technically, he never said embezzlement, but I'm not sure how the courts will see that.
A partial win for Oz because
that's definitely a partial win.
The 9th claim for relief. Oz objects to plaintiff's 9th claim for relief for computer fraud. Okay, now this is sticky. This is where I get really...
Computer fraud. Was this him allegedly hacking into the computer?
Annoyed with the judge, okay? Remember we talked about how the judge had ordered her to file a second amended complaint, basically to give the specifics that the court asked for and to spell it out so the court could clearly see what she was alleging was defamatory. And she didn't do that. And the court has even said that she didn't do that. But we talked about how Blair's team took the opportunity in filing this second amended complaint.
They added to it, didn't they?
To add in a claim for computer fraud. And I had said that in my opinion, when I read the court's order, it is clear to me that what the court's inferring is you need to file a second amended complaint because you need to give us more detailed information about what you're alleging.
More detailed information, not new information. Okay, I see what happened.
It's defamatory here. And Blair's team argued that we're throwing this in because the judge just said file a second amended complaint and didn't say we couldn't. And to me, that seemed like a ridiculous argument. But this is not...
I mean, yeah, but technically, if it's not there, it's kind of like arguing with an HOA, right? If it's not in the rule book, you can kind of argue yourself into an issue. Yeah, so it's just... Yeah, I guess they could. They kind of got away with that,
Now
didn't
what
they?
the court has to say, and I'm really disgusted with the judge.
Oh.
So it says Oz objects to plaintiff's ninth claim for relief for computer fraud on the ground that amendment to include this claim was not approved by the court.
I mean, I understand where he's coming from, that the court should have not allowed this necessarily, but there's so many lawsuits out there where additional stuff is, comes out during these stupid amended complaints that they're like, yeah, I'll allow it. Yeah, I'll allow it.
And it responds that the court's order of January 15, 2024 authorized the second amended complaint without restricting the claims that could be alleged in it. I'm not sure, but it appears to me that the judge, this is a typo, and that it should say plaintiff responds that.
Oh, wait, let's take a look. Defendant responds that the court's order authorizes the second amendment complaint. Yeah, that does sound like it should be plaintiff, because that sounds a little weird. Huh. Weird.
The court's order authorized the second amended complaint without restricting the claims that could be alleged in it, because that's what Blair's team argued. So I think that's just a typo. The judge says, I agree the order was not clear as to the scope of the second amended complaint.
Okay, so then the judge is saying, yeah, all right, I just authorized it because I didn't make it clear. So they just chose to allow it in, which they can do. I mean, it's not great necessarily for the defendant, but like, okay.
That it authorized. While the order was clearly issued in response to defects in the defamation claims, it did not expressly limit amendments to those claims.
All right.
Before I read the rest of this, the other thing that we have to remember is not only did she not comply with the court's order in the second amended complaint to give the detail the court wanted, but she filed it a week late and didn't get the court's permission.
I can see that happening in a couple of cases, primarily ones where the court is overloaded. So if they're like, well, we got this murder trial that we're doing this week, that's more important. Who cares? We'll just let it go. I mean, courts are litigious in a lot of ways, but they're also filled with people who are a lot of slackers.
And the judge had said that it had to be filed on a certain date or he would grant the motion to dismiss. And he didn't do that. And she didn't ask permission to file it late. She just filed it late. So that...
I mean, we're assuming that she didn't ask for permission. Like it was probably in there saying that she didn't ask for permission, but maybe someone actually got to the judge or something, or maybe there's like some weird word of mouth thing with like a clerk, and then the clerk got fired for this. I don't know. I'm just making shit up. Don't
annoys
listen to
me too that he's giving her leeway. So this is the rest of what he says. I will resolve the issue with an eye to practicalities. No objection has been raised to the ninth claim for relief other than the authorization issue. Were the court to require a motion to amend in order to address this new claim, it would only delay the long-delayed case further. Now, why would the court allow them to file a motion to amend the complaint again?
The only thing that makes sense is they were already too busy with another case. That's the only thing that makes sense, and they didn't want to drop it because it was an interesting case to them. That could also be it. People are selfish in a lot of ways.
I thought the court had said the second amended complaint was going to be it. So you're saying that because maybe the order wasn't specifically clear enough, even though the court says it was in response to the defects in the claim.
Is this a new judge, or is this just a super lenient judge who just likes to work on unique cases? Because this is definitely one of the probably more unique cases they would have worked on.
Claims for defamation. The court's now going to reward her for being late in filing her response and for throwing this extra item in for which she's not gotten permission from the court, and yet the judge is just going to let it ride? I think that's preposterous. So this is basically now a third amended complaint.
I mean, yeah, that's exactly what this sounds like. But it looks like the judge made the decision, and what are you going to do? I guess you could sue the judge at a later date. I mean, think about it this way. 60% of the world's lawyers are in the U.S. We are the most litigious country in the world, and we sue each other for everything, and we make up stupid new law books every other day. Have you seen, like, the law books of the U.S.? They are massive. Like, just if you stack them end on end, just you should see how tall they go. It's ridiculous.
And he's given her way, way, way too much leeway. And if I didn't know better, I would think the judge was partial to Blair's side. So he's saying that He's going to treat the order as authorizing all remaining amendments to the complaint, and he's going to approve the inclusion of the 9th claim for relief in the second amended complaint. But it will be my expectation that the complaint is now in its final form. I thought it was in its final form the last time.
There's something that we're missing, and it's got to be something either just due to court scheduling or that one of her lawyers is like a nephew or something of the judge.
Now it's in its final form. So even though he told her
Allegedly
that she needs to amend it to clarify, because she's thrown this in, he's going to say, well, I didn't mean that was the final one. Now it's the final one. Conclusion for the...
I guess there could be one other consideration. The judge may have needed to be, I guess, schooled on how YouTube kind of works. So maybe there's like a little point in there and they're like, okay, maybe I didn't understand exactly what was going on. And they were kind of like being like, okay, because I didn't understand what was happening, I'm going to take an L and just approve it. But I don't know. It is weird. It is definitely weird.
The reason set forth above, Oz's motion to dismiss is granted in part. Dismissal of the first and fourth claims of relief against defendant Oz is granted. Dismissal.
Okay, so at least he got a partial dismissal, and there's only a couple left. But the problem is the two that are left are pretty bad.
The third and 9th claim for relief is denied. So basically, what we're left with is the 3rd and 9th claims for relief, the defamation in terms of the allegation of embezzlement and of the coercive financial relationship, and this new 9th claim for relief for computer fraud. Now, even though...
Is the computer fraud one? I didn't specifically see it on there, but I thought that was the one where he allegedly hacked into her computer.
I'm mad at the judge for giving her so much leeway. It does not mean that he's saying she's correct in what she's alleging.
Right.
Okay? That's got to be determined at trial by presenting evidence. She has to support all of this with evidence. And Oz will have his chance to present evidence to refute what she's claiming. So that's what the court has ruled on Oz's motion to dismiss. It's a partial win for Oz. It's a partial win insofar as it didn't get dismissed for Blair. It's not an endorsement of the validity of her claim. The court doesn't feel comfortable dismissing the rest of it at this stage, which is unfortunate because I think this is a waste of time and money. But now let's take a...
Every lawsuit in the U.S., I'm sorry, not every lawsuit, 95% of all lawsuits in the U.S. are a waste of time and money. That's why it's such a great idea to be a lawyer.
Look at Felix the Kit Kats. Now, I thought of all of the 3 defendants, Felix the Kit Kat had a slam dunk.
Yeah, I don't know. I don't know why everyone thought Felix had such a slam dunk case, because when I heard about it, I was like, but it really sounded like Sad Milk LLC was underneath Pyramid in my eyes, from what I could tell from the videos I saw. And then he worked as a contractor underneath Sad Milk to find stuff on the Click, which the Click was probably, by the way, also a contractor because he refused to sign the non-disclosure agreement that she had. He didn't sign it, which means he would probably be a contractor. He probably wasn't directly involved with Sad Milk. Remember, Illuminati took care of all the back end. I bet you these guys weren't necessarily employees in the general sense. They were probably all considered subcontractors underneath Sad Milk, not actual partners. Partners would have been required to sign the non-disclosure agreement, most likely. So, for instance, even though Felix probably signed the non-disclosure agreement, he probably signed it under Sad Milk's LLC, but as a subcontractor, not as a partner necessarily, just because. Now, here's the thing: he signed it later, right, when he actually got hired. So it still shouldn't work necessarily retroactively, but I don't know. But maybe the court seems to think otherwise, that works retroactively, because technically it wouldn't have applied if he had given that information to the Click earlier, like before he was hired, but he gave it after he was hired. So, like, for instance, if I got hired at working for, Google, right? And I had worked for a subsidiary of them at an earlier date, I might not be legally allowed to take any of the information from that subsidiary and give it to someone else. I could be sued by Google and or Pyramid in this case. So that's where I think Felix is kind of stuck.
In terms of getting his dismissed. Well, the judge has disappointed me there too. And we're going to talk now about what he said. And this one's pretty short, but I was scratching my head after I read it because I was like, what? So here we have Plaintiff Pyramid Entertainment versus the defendants. Order regarding defendant Felix the Cat's motion to dismiss claim for breach of contract. Before the court is the motion filed by defendant Felix seeking dismissal pursuant to Rule 12b-5 of plaintiff's breach of contract claims against him in the second amended complaint for failure to state a claim. I previously allowed amendment of the complaint, following which Felix renewed his motion to dismiss. I've reviewed the renewed motion, the response, and the reply, along with the case file and applicable law. I'm not going to go over the legal standard again because we went over it in just a minute ago in Oz. What constitutes failure to state a claim for relief? So we don't need to go through that again. It says, under the Warren standard, the trial court still accepts all allegations of the claim as true and views them in the light most favorable to the plaintiff. However, facts pleaded as legal conclusions are no longer entitled to presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. And so here he is doing an analysis. He says, viewing the amended complaint in the light most favorable to the plaintiff, the court accepts that the portion of the YouTube video referenced in paragraph 63-64 of the complaint is the same as the one displayed via screenshots in paragraphs 116 to 20, which has the same link. It shows Blair instructing her employee, Felix, to help me find Click, a former employee now.
So here's the question. Was the Click a former employee or just a subcontractor? Because that's going to be a massive difference when it comes to how the law works. Okay, so, and he was searching through Sad Milk's raw audio file. Well, Sad Milk is a subsidiary of Pyramid, so anything underneath Sad Milk would be linked to Pyramid, which means if you do anything for Sad Milk and then you start working for Pyramid, then generally you can't necessarily release any stuff of the stuff you worked on because you are now working for the parent company. That you're still held by the same non-disclosure agreement. It kind of goes across all of their subsidiaries in most cases.
Now competing YouTuber competing. They don't do the judge. I don't know if you watch YouTube, but
okay, so competing just means other YouTuber in this case. It'd be like, for instance, they're probably referencing it along the same lines of, let's say a news channel versus, a reality TV show. Technically, they're competing because they're both competing for airtime. They are not even remotely the same, niche, I guess is what you could say, but that may not matter in certain types of law.
They don't cover the same.
But they're not like, it's not like John Deere lawnmower against Home Depot's lawnmower. Okay, that would be direct competition, right?
Stuff, so they're not really competitors. That's like saying that, the car dealership is in competition with the computer sales shop.
Right. Yeah, so the Clicks videos don't even compete at all with Illuminati. They're not even the same genre. I didn't even know they were linked together at all. So that's most likely Blair just playing on the fact that the judge has no idea what this actually means, which means it's just going to be brought up in court. So there's that. So I guess it's not the judge just doesn't understand at this point.
Shop, she wanted him to find Click saying the R slur, and it's here, but I'm not going to read it, in Sad Milk's raw audio, and offering to pay him $200 to find it. Sad Milk's YouTube channel created and managed by Plaintiff Pyramid.
So yeah, here's the thing. Remember Blair kept saying she was the one doing all the work in the background? Well, it sounds like she was the only person actually doing any of the actual, pay and stuff in the background, which means she may have been paying these people. These people might not even been working technically for Sad Milk at all. She could have been paying them just like friends and family level stuff through PayPal. Because up until like 2019 or whatever, or was it 2020? When did they change it to where businesses couldn't do friends and family, or at least not in the same way? There was something about that, so there is that chance. But yeah, I'm gonna say that. Maybe these guys weren't actual employees. So, like, for instance, Felix the Cat was a subcontracted employee of Sad Milk potentially, but actually, it was probably of Sad Milk. Well, maybe not. I don't know. It doesn't matter because basically it was either Sad Milk or Pyramid, but Sad Milk was underneath Pyramid as an umbrella. Pyramid was like the umbrella corporation, effectively. But any non-disclosure agreement you would sign, which he may have signed, I don't know. So let's say he didn't sign it the first time, right? He found this stuff. He got paid the $200, right? Well, as soon as he became an actual employee of Pyramid, he wouldn't be allowed to use those to be able to post those clips to the Click. It'd basically be locked the moment he got hired, right? So that's when he signed that non-disclosure. It kind of worked retroactively in the fact that he just can't go back and send those clips out because Sad Milk is actually a part of Pyramid. That's where I think it's a little bit different here. Whereas a lot of people were like, no, he didn't work for Pyramid, and Sad Milk were two separate things. But it looks like Sad Milk was entirely underneath Pyramid, which is the problem here.
And that's what Blair said in the complaint. Again, viewing the amended complaint in the light most favorable to plaintiff, these allegations arguably state plausible claims for relief of both the NDA and the Felix agreement. They arguably state a plausible claim for breach of the NDA in that they plausibly allege that Felix, without permission, shared with a third party Pyramid information.
So he shared Sad Milk information potentially because he probably thought he was working under Sad Milk's LLC, but didn't realize that Sad Milk's LLC was underneath Pyramid. He probably thought he was just only working for Sad Milk. So when he got hired for Pyramid, he probably didn't realize that his Sad Milk stuff that he did before applies to the Pyramid non-disclosure agreement. Because it may not have been stated specifically. It probably should have been, but I don't know. We'll see how that works.
Company operations, as well as information regarding an individual's involvement.
Yeah, okay. So in this case, apparently the judge is like, yeah, you can totally go look for dirt on another person. That's maybe that's how news sites fight lawsuits.
In Pyramid operation. They likewise arguably state a plausible claim for breach of the Felix agreement. They allege that Felix, without permission, shared with a third party confidential information for the benefit of a third party. Now, here we go. Okay, first of all, it sounds like the judge is accepting Blair's assertion that Sad Milk was managed by Pyramid. Okay. I'm going to talk about in a second why all of this is nonsense, but let's just examine that. So, Click wouldn't be a third party then.
Click could be a third party if he wasn't an actual employee. We don't know. What we do know is Click and One Topic never signed any sort of agreements when they worked for Sad Milk, which means there's a good chance that they were just paying cash to her and they were never actual employees underneath the Sad Milk LLC, because it sounds like Blair did all of this on her own in the background. So there's a pretty decent chance that they are not actual employees or never were, which may be a problem here. And we don't know. I don't know if we'll actually get that information necessarily. Felix might, but we'll see how that turns out.
Because Click was part of that whole Sad Milk operation. So it would be from employee to employee, wouldn't it? If you're trying to say that Sad Milk is the entity here, then sharing Sad Milk information with the Click would be basically an internal share, wouldn't it?
Only if the Click is actually an employee. So that's the thing. There's a good chance that the Click was never an employee, which means this wouldn't be internal necessarily. He'd be effectively a guest star at all times, which a lot of people do it that way, especially because they don't want to be screwed over. And a lot of YouTubers do it that way. They'll run their own company, but they'll have guest stars on, and they won't necessarily have anyone who is also, even if they're a regular on the podcast or whatever, they won't have them as part of the company. They'll just have them as guest stars, and they'll pay them cash under the table and whatnot. So that could be a problem here.
Isn't it? So he's not a third party. He was part of the operation. So first of all, that right there, that doesn't make any sense.
Do we have 100% confirmation that all these people part of Sad Milk were actually all employees? Was that ever written down anywhere? Because that's what I want to know. Because if that's true, then yeah, he's right. But if they weren't employees, then
here, But it gets better, okay? He likewise arguably stated a plausible claim for breach of the Felix agreement. They allege that Felix, without permission, shared with a third party confidential information for the benefit of a third party. Okay, first of all, how does it benefit Click? That Felix is telling Click that Blair asked him to do this. I don't see how that benefits Click.
Yeah, that doesn't make sense.
It's basically saying, look, dude, she was trying to screw you over. I don't see how that benefits him in any way other than just to make him aware of it. But again, we're talking about in the context of Sad Milk, then they are all part of that group. So how is this a third party situation?
I kind of want to see if I can pull this up real quick. I'll see if we can even pull up Sad Milk's LLC. Which I don't know if it will actually have anything about their employees. Sadmilk.info maybe. There's a good chance that that we won't be able to find any of this data. Apparently there's other versions of Sad Milk that have to do with security weaknesses. So we'll deal with this later. Yeah, I don't know. That's
but
the
here's
big
the part
thing for
that
me.
really bothered me the most. The confidential information discloses not, as Felix's counsel suggests, that Blair uses the Arsenal in private. That would be a private matter rather than company business. Rather, the potentially actionable conduct by Felix was his disclosure of internal company messages and operations, namely Blair instructing her employee to find potentially damaging information about a competing YouTuber. Click. Again, Click was part of Sad Milk.
That's what I want to know. Was Click actually a part of Sad Milk? So that's where if you guys can go in the comment sections and actually tell me, where was it stated 100% that Click, One Topic, or anyone aside from Blair specifically was actually in Sad Milk as an actual written down employee versus like a subcontractor or a guest star? Because guest stars you can still pay money to without actually putting them on the books for taxes. So I want to know if they were actually on the books as an employee, because that's the big thing here. Because if none of them were on the books as an employee, then this actually makes more sense. On
What's
Blair's
he
side,
talking
anyway.
about? While disclosing such tawdry information to a competitor may not
Or she's lying. Or she's lying.
be a violation of the Uniform Trade Secrets Act, it could plausibly be a violation of the agreement that Felix signed as it disclosed to a competitor. He's not a competitor, Judge. You're assuming that all YouTubers are in competition with each other.
I mean, from a standard definition, all news sites are in competition with each other. All TV shows are in competition with each other. The competition is there's only so many viewers, and there's only there's so many videos uploaded at any one point. They could be in competition just from a view standpoint. That would be the roughest definition. It wouldn't be like, yeah, it's not two car companies who are in competition with each other. It's just two entities that are on the same platform are in competition with each other in a general sense because they're taking potential viewership from each other. Example, 4 million videos are uploaded to YouTube every single day and only so many viewers. So the only thing that's going to make a difference here is whether or not the Click was an employee or not.
That's just ridiculous. That's like saying the New York Times is in competition with People magazine.
Technically, they are. They're not directly in competition with each other for actual people that would buy the magazine. People who are buying People magazine may not buy something from the New York Times or something like that. But technically, they are in competition because they're both publications. That would still not hold up in court, but it might hold up in pretrial. So, like right here. So, for instance, in court, it would be most likely dismissed. The only thing that wouldn't be dismissed necessarily would be as if they're employees or not employees.
They're not in competition. They're not even in the same ballpark. Click does like silly Reddit stuff. Blair
they're completely different.
exposes MLMs, or used to.
The only way she could be in competition is if she didn't delete all of her original stuff, right?
They're not in competition,
Which was all Reddit
Judge.
stuff.
Educate yourself on what these people do. It could plausibly be a violation of the agreement that Felix signed as it disclosed to a competitor the internal operations of a company. whose business arguably involved trolling for clicks and bringing down its competitors. Now he's confusing Sad Milk with Pyramid here. Sad Milk, that's not what Sad Milk did.
Yeah, Sad Milk was just another meme channel. Pyramid, on the other hand, does that.
That's what Blair does in her Illuminati channel. So the judge is like conflating a whole bunch of stuff here. As the complaint alleges, large amounts of
Okay, so there's obviously the judge obviously doesn't know a lot of what's going on
money
here.
were at stake. Please. Large amounts of money. How are they at stake? How is Felix telling Click that Blair was trying to screw him over involving large amounts of money? But here, aside from my issue with Judge,
Yeah, that doesn't make sense. I definitely agree with MadCaster on this part. Absolutely, that makes no sense at all.
not understanding the business that these people.
That's also, the judge obviously doesn't understand the business here. I just think that Click probably wasn't an employee of Sad Milk LLC. Although I'm sure someone's going to put a Google Doc down my description and be like, here, this is where the Click signed as a partner to Sad Milk LLC. But I don't know. I don't think they would have.
people are in and their differences in what they do. I'm annoyed with the judge because there's one glaring fact here, that should automatically have had him dismiss this. I told you guys in my video, one of my videos, that if you look at the messages that are at issue, first of all, they were not company messages. They were private discourse between Blair and Felix. It had nothing to do with the company.
True. The problem is Blair's Discord considered part of Pyramid LLC? Could be. Lots of companies add Discords to their company social media, whatever you want to call it, programs. Not programs. The thing that, it's part of their employee handbook things.
She was paying him out of pocket $200, not as an employee, but as someone who was not an employee.
Right. This is when he got paid the $200 as effectively a subcontractor. Now the question is, he obviously was doing additional work for her because this was not the first time he ever got paid from her, right? So from that standpoint, he wasn't an employee. Okay, great.
But I'm trying to get him to do some dirty work for her so that he could earn a little bit of extra cash. The glaring problem with this is the messages were created. Not only are they not company messages, a year before he signed his non-disclosure agreement. And
yeah, that's the thing. So, I mean, in one general sense, non-disclosure agreement only works forward from anything else. But the question is, if those messages were on, if those messages were on the Discord, and that Discord was part of Pyramid's LLC in one way or another, and if he took the screenshot, let's say it was saved a year in advance, and he just went back into it and then took a screenshot, would the screenshot be based off not the date that the conversation took place, but the point he took the screenshot? Because that could then be, effectively be sharing old company information. So
went to work
I'm not sure how
for
that would
Blair
hold up.
in her pyramid company. So he was not an employee, Judge, number one. Number two, the messages weren't company messages.
But we don't know that. They could have been company messages within the Discord. Just because they weren't in the public part of the Discord doesn't mean they weren't in the private sphere of the Discord. Now, he's referring to the fact that Felix's messages weren't in the company aspect. But was Felix a mod at this point? He could have been like an unpaid intern, which could still apply here. Now, hard to say. I think the judge is definitely just misinterpreting a lot of how this works, because he's thinking of it like a Slack account potentially, which is all linked within the company itself, whereas Discord isn't Slack. Okay, it's not Slack. It's not a it's not the same necessarily. But the problem is a lot of companies also use Discord now for their own internal company memos. It could, in theory, work.
They were a year before he was an employee, and they were private messages between the
Right.
two of them. So they're not
But were they private? Because he was, I think, a mod at this point. So if he was a mod, they might not have been as private as everyone
covered
seems
by
to
any
think.
of this. The NDA has nothing to do with those messages. And
So he's definitely got more a law degree on me here on this one. It's just I have NDAs, which is part of why I know some of the stuff here. But my only question is whether or not he was actually an employee of Blair's, even if he was just a moderator at the time. So he could have been an employee of hers. It just may not be made clear to the internet yet. So the problem is Blair is holding a lot of financial information back, and a lot will depend on discovery here. So it'll either just instantly get dismissed once it actually makes it to trial, or there's a bunch of stuff missing, and Felix was actually an employee for a lot longer than he's claiming to be. Or at least he didn't understand he was an employee, which is a high possibility as well. So now, as for signing the NDA in the future, it depends on if he went back and took those screenshots from the Discord. Like, for instance, if it wasn't necessarily, if it was a part of, if it wasn't part of like, what are you gonna call it, private chat. If it was actually within the mod Discord instead. So, for instance, if it was private chat, then maybe then we'll definitely say that wouldn't make sense. But what if it was within mod Discord, like, and it wasn't a private chat. It was within Pyramid's Discord. What if that was the case? Anyway, just a thought.
so it should have been crystal clear to the judge that automatically that
You're talking to a
made
judge
these
doesn't
claims
know anything about
bogus,
YouTube.
and he should have dismissed Felix out of this lawsuit. I thought it was black and white, cut and dry. Apparently the judge, in my opinion, is not doing his due diligence in understanding what's going on with these people and what they do and how they interact with one another. I rolled my eyes when I read this because I was like, oh my God, you're kidding me. So poor Felix has to continue to fight this when he shouldn't have to fight it. If I was his team, I would file a motion for reconsideration.
Yeah, I mean that makes sense. I'm just concerned that a lot of the Sad Milk people weren't actually employees, and then that would be the big thing for me. Now I'm not going to do any deep dives, so feel free to go in there and tell me I'm an idiot. I don't care.
And I would make
I don't
it
care about any of
very
these people,
clear
really.
to the judge and provide the NDA and the messages and say, Judge, it's right in front of you. The messages were not done while he was an employee. Therefore, they're not covered by the NDA. So dismiss it already. And
It just depends on if it's in public, if it was in a public space or not. Because even if you sign one in the future, the only thing that bugs me about this is if he signed the NDA in the future, but then went and took a screenshot while underneath the NDA of that conversation, but that conversation wasn't in a private message, but in a company message. Even if it's the original message was in the past before the NDA, the screenshot would have been in at the time of the NDA. So he basically, the original message was fine, but if he had the screenshot after he signed the NDA, that might be the problem because that's easy to tell. You can easily check the metadata for that. So that would be one thing that we might be missing here.
And so I hope they file a motion for reconsideration. If they're listening, file a motion for reconsideration, guys. Come on, this is ridiculous that this is going to continue. It says, for the reasons set forth above, I find that Claim 1 and Claim 2 in plaintiff's second amended complaint each stated a plausible claim for breach of contract against Felix under the Warren standard, and accordingly the motion to dismiss is denied. Well, I think that's a travesty for the reasons I just stated. Felix shouldn't be in this. And Blair, shame on you. Shame on you.
I mean, the only thing that makes sense though is those screenshots have metadata that prove that they were taken during the NDA. That's the only thing that would make sense to me.
Shame on you for terrorizing and going after this kid for something that's a non-issue. I'm sorry if you don't like the fact that your dirty tricks got exposed, but he didn't breach his NDA. Not only that, but Felix should file a suit against her to invalidate that NDA. They all should. Those NDAs aren't worth the paper they're written on. They're too broad. They were written basically for high-tech companies. So, she cut
Yeah, those sound very familiar to certain companies I worked with.
pasted probably from the internet because she didn't want to pay somebody to draft her an appropriate confidentiality agreement and an appropriate NDA. I think all three of them are invalid. I don't understand.
The problem is the judge doesn't know enough about YouTube, and they're like, well, I don't know enough about this, so I'm just going to let it go to trial, is basically what's happening
Why
here.
it wasn't made crystal clear to the judge that, look, date here, date here. They don't correlate, Judge. This thing she's complaining about happened before he...
I think everyone's taking the date of when the words were, or the thing happened, and not the date when the screenshot was taken. Because I think that's what happened here. So the judge is probably looking at it and be like, well, the screenshot was taken after. It's right there on the date it was last modified, or when it was first modified, because you can check first created, right? So, that's what I'm guessing is what the judge is looking at. He's like, well, obviously this was taken after the NDA was signed, regardless of whether or not the information on the inside was before the NDA was signed. So he's basically going off the fact that the click was given this information after Felix signed the NDA. And he was given a screenshot, which was taken after he signed the NDA. Not that the original information was given to the click before he signed the NDA, which is the problem, I think, that the judge is seeing.
He signed this.
Regardless of the information being done a year or two.
Tell me what you think down below. I'd be interested to hear it. Are you as disappointed as I am? So we're going to mark.
I mean, I'm disappointed, but I'm honestly not surprised at how the law is, the courts are doing this. Why would they dismiss it outright when they can let it go to court and everyone keeps getting paid more money? I mean, what are we expecting here?
March on. At least we got part of it dismissed. And as far as Wonder goes, I know we haven't really talked about it, but Wonder was never served. So I'm expecting, I don't know why it still hasn't happened, that the court's going to dismiss Wonder from the complaint because he was never served. I still think ultimately Oz is going to prevail. It just seems like a waste of time and money on it.
I'm not sure everyone's going to prevail here. I think it's going to be a big problem for everyone. I think a lot of people on the internet are going to be a bit disappointed with this one. It just doesn't seem like it's as cut and dry as the internet makes everything seem to be. More and more stuff comes out in, I was going to say in judgment. That's not right. In discovery that is never posted online. So there's potentially some interesting things here that we're kind of missing. Big thing for me is I want to know if only Blair was the only employee of Sad Milk and everyone else was just either a subcontractor or she made it so everyone was a guest, because that could be a huge problem for Felix.
Everyone's part, and in fact, a lot of you know and have pointed out to me, and I did watch it. Oz put out a video a few days ago where at the end of it, he made an open invitation to Blair and her team for them to just settle this whole matter and just move on with their lives. It's my understanding that Blair's team has responded to him, saying that they will consider it. We'll have to see how that's...
I'm surprised they even said they'd consider it. Either Blair's running out of money, or she just wants to go scorched earth and just doesn't care anymore.
...develops. Go watch Oz's video. He's also been live streaming like every night. They're raising more money for the legal defense. Let me know what you think down below.
Oz is definitely going to need a lot more money for his legal defense, so definitely go donate on his channel. Also, I believe if you donate and it gets dismissed, you get a refund, so that's a nice bonus.
Thank you for joining me. I'm sorry, I know my voice is still hoarse. I've been out of the hospital 2 weeks now and I still can't talk, but life goes on. I have to keep going. Thank you so much, you guys, for your support. Thank you for getting me to 50,000. I want to say thank you so much, as always, to our Patreon patrons. You guys are amazing. We've added a couple of new patrons. The list keeps growing. And
so I believe the majority of money that goes to MadCaster helps support. He fosters cats, to my knowledge, so it supports a lot of his causes with that. The same with the channel. So, and you can also donate complete like random things from the Amazon wishlist too, which is pretty cool. So I'll probably go do that a little bit later. But yeah, MadCaster's got some really good takes on legal stuff. Obviously, my takes are stupid, so you should just take my takes with a grain of salt and then go yell at me in the comment section because I apparently like hate watchers. And then we'll get back to what I really like in doing is watching songs like Tom Cardy and the stuff from the Internet Explorer, the Internet Historian. I like watching the essay stuff. I'm not really the best when it comes to live drama between channels for people I honestly could care less about. I'll be honest, I don't care about Illuminati. I think she's crazy. I also don't technically care about Oz or Wonder or Felix because I just don't personally care about these people. It's interesting to talk about to me, but it's not like I'm not going to like hold the torch for any of these people. And I know a lot of you in the comments will, but that's fine. You guys can totally do that. So feel free to call me an asshole. All right, have a good day, everyone.
As I've stated a million times.
Maybe I should press the right button and actually end the recording.